So in addition to all of the UK patent litigation we've covered already, 2023 was also a big year for European patent litigation in general, because we saw the start of the Unified Patent Court after many decades in the making. Unlike our top UK patent cases, we're not going to limit ourselves to 2023 for the UPC today, because we're only 9.5 months into the new system. So quite a few of the interesting updates have happened this year. So we're taking ourselves up to present day for the UPC. So the original idea behind the UPC system was that it would create a one-stop shop for patent litigation in Europe. So you wouldn't have to bring all of these parallel national actions. You could get a single decision that covered Europe in one go. As you can see from the slide here, that hasn't entirely been achieved. So currently the UPC covers the 17 countries shown in orange here. Everything else is outside the UPC. The countries in yellow on the slide are ones that may or may not join the UPC in future. So they're the countries that have signed the UPC agreement but haven't ratified it. And then we have the countries in light blue, which are EPC contracting states, but they aren't ever going to join the UPC, either because they are not EU member states or they've just said they're not interested. So we've obviously got a bit of a patchwork here. And as a result, it's likely that national litigation is probably going to continue alongside UPC litigation, even after the transitional period has expired. So now, just as a bit of a recap, the UPC has jurisdiction over disputes within the UPC territories relating to both the new unitary patent and what we now call classic European patents, at least classic European patents that haven't been opted out of the system. So unlike a classic European patent, a unitary patent is a single right covering all of the UPC territories at the time of grant, and it can't be opted out of the UPC system, so it has to be litigated within the UPC. So if we look at the figures here, you can see the number of registered UPs as of today is over 21,000. That represents a bit over 18% of all patents granted by the EPO since the unitary patent has been available. So clearly most patentees are still opting for the classic European patent, but a not insignificant number of patentees are taking up the new unitary patent option. Moving to our classic European patent, the EP, so far we've had almost 600,000 opt-outs filed. That's probably about 40% of all European patents. And it's more than tenfold the number that the UPC Administrative Committee had expected. So might explain why the CMS fell over in the early days when everyone was filing their last-minute opt-outs. You can see that we've already had over 1,500 opt-outs withdrawn. And in fact, we've seen some of those re-opted-in patents asserted in the early UPC cases. So now this slide just sets out the top 25 unitary patent proprietors at the moment. I'm not going to spend too long on this, but it's interesting to see the companies that are engaging with the new unitary patent. So you can see a lot of engineering and electronics companies in there, but also quite a few life sciences companies as well. So in fact, Johnson & Johnson is the top unitary patent proprietor at the moment. So now onto the cases. You can see the numbers here on the slide. Just to explain that this applies a UK-style approach to counting cases rather than the German style. So if an action has been brought against multiple defendants, that counts as a single case in these figures. So you might see some UPC figures that give the case numbers as much higher. That's the reason ours don't look, we're not in the many hundreds here. The cases started as quite a slow trickle in June last year, but actually the numbers have ramped up over time. They cover a range of technologies, so we've got everything from electric cars to e-cigarettes to antibodies, medical devices, and everything in between. Interestingly, for me as a life sciences lawyer, we haven't had any traditional originated generic litigation in the UPC yet, but that may come as time goes on. You can see from the figures that the UPC so far has been much more popular for infringement actions than revocation actions. So we've got 96 infringement actions, and so far counterclaims for invalidity have been filed in 39 of those actions. So clearly invalidity will be a big feature in UPC cases, but it's coming more as a counterclaim to an infringement action than as a revocation action. The 25 revocation actions there, in fact, 10 of those have been filed by a single company, a company called Enjoy Netherlands, which is an e-cigarette manufacturer. So, in fact, there are very few parties filing revocation actions so far. I think we have to speculate a bit as to the reasons for that. So the system may be more attractive to patentees, particularly at the moment. Patentees generally have a lot more choice in the system, so they can engage in forum shopping. In many cases, a patentee will have a choice over which division to file their infringement action in, because they can file in any division in which the alleged infringement is taking place, or where the defendant has a place of business. So they can, in many cases, pretty much choose their judges. In contrast, a revocation action simply gets filed in the central division and gets assigned to the seat that's responsible for that particular technology. And in fact, the central division is still in a bit of a messy kind of interim phase at the moment. In the long run, there will be 3 seats of the central division in Munich, Paris and Milan. But at the moment, the Milan division isn't up and running. It will be operational from June this year, but not yet. So at the moment, only the Munich and the Paris divisions are hearing cases. And so that may be one reason we're not seeing many revocation actions yet. Obviously, also, a revocation action can only be brought against a unitary patent or a non-opted out European patent. So the patentee has some control over that, and perhaps the weaker patents aren't in the system at the moment. But we'll see if that changes as time goes on. So looking at where these infringement actions have been filed, you can see here there's been a clear winner in terms of the choice of divisions. The German divisions have been by far the most popular. In particular, the Munich division, which has taken 36 of the 96 infringement actions. Looking at language of proceedings, for revocation actions, English is by far the most popular, but that reflects the fact that revocation actions have to be brought in the language of the patent. So English is the most popular language of patent filing at the EPO, and hence revocation actions are mostly in English. When we look at infringement actions, German is the most popular, followed by English. But actually, there's been a shift over time. In fact, German had a much higher percentage of the proceedings early on, and it shifted towards English as time has gone on. One reason for that is probably that the German divisions didn't confirm until just before the UPC start date that they would accept English for proceedings. So it's likely a lot of the early cases were prepared in German to be filed in the German divisions. We've also seen cases where the language has changed to English in the course of proceedings. So in some cases, the defendant has asked the court to change the language to English. One of those cases was Planty and Arkine, another one was SodaStream and Arc. In both cases, the defendant was quite a small company and said it was disproportionate for them to have to run the proceedings in a language they didn't work in, and the court agreed. We've also had cases where the parties have agreed to shift to English. So Sanofi and Amgen is one of those cases. And in one case, 10x Genomics and NanoString, the first instance PI proceedings were held in German, and then in the Court of Appeal, they shifted to English. I think that reflects the fact that not only is English often the preferred language for many parties, but it also increases the pool of judges that can hear these actions, because I think all of the UPC judges speak English, but not all of them speak German or Dutch or the other languages available. So now, on to the early decisions. We don't have any main action decisions yet because the first trials won't take place until the summer, but we do have quite a few decisions on preliminary injunctions and provisional measures, and also on access to documents, which we'll cover briefly. So this slide summarises the early preliminary injunction decisions. you can see from this that the UPC isn't simply handing out PIs to anyone who requests one. In fact, we've only had 3 PIs granted so far, and one of those has been overturned on appeal. So that's the 10x Genomics and NanoString case. Just to flag, there are actually 2 PI decisions between 10x Genomics and NanoString. 10x Genomics asserted a parent EP and also a divisional UP against NanoString. So there are 2 decisions we refer to there. I'm not going to go into all these decisions today because we don't have time and we all want to move on to drinks pretty soon, but I'll just cover some of the key points that have come out of them. So firstly, the UPC has demonstrated that it can and it will act very quickly to issue ex parte orders where urgency has been established. So all of the cases shown here in the bullet point are cases where an ex parte order, whether a PI or a seizure or inspection order, were granted within a day or 2 of the application. And in each of these cases, there was a trade fair or an exhibition going on, so there was a very time-limited period during which the remedy needed to be granted. One of these cases was quite surprising. Actually, that's the Maestromer and Revolt case, one of the very early cases by the Düsseldorf local division, in that the defendant, Revolt, had actually filed a protective letter with the UPC here. But despite that, the court went on to grant the order ex parte. And the reason for that, it appears from the judgment, is that they felt that they'd seen the defendant's arguments on invalidity and lack of infringement. So they felt that they'd sort of taken that into account. They weren't convinced by that, so didn't think they needed to go on to hold an inter partes hearing. So I think that served as a bit of a warning for potential defendants in the UPC. If you're going to file a protective letter, make sure you get some really good arguments in there. Another interesting point, perhaps surprising to some, is that the UPC decisions have shown that the courts won't always require a security in return for a grant of a PI. So one of those cases was 10x Genomics and NanoString. This is the divisional patent case where the PI was granted. In this case, the Munich local division said they exercised their discretion, and they said they didn't see that there was any need to request a security. Essentially, on the evidence, they thought 10x Genomics was good for the money, and they didn't see any issues with enforcement. And there was a similar decision in Aim and Suppenor. In that case, actually, the PI wasn't granted, but the court said that had they granted the PI, they wouldn't have required any security. Maestromer and Revolt, which is the ex parte decision we discussed earlier, in that case, they did require a security, but the court was very flexible and didn't require it to be paid in straight away. So they said Maestromer simply had to make the security payment within 10 days of PI grant. So quite lenient there in terms of requiring security. The other point we've seen from the inter partes decisions is that local divisions, at least in some cases, will really dive into the detail on both validity and infringement when considering a PI application. So the first 10x Genomics case, where the PI was granted by the Munich local division against NanoString's mRNA and protein detection products, involved 2 full days in court and a judgment running to over 100 pages. So it'll be interesting to see how the court deals with trials this summer, which are meant to be limited to 1 day in court. But there's really a lot of detail considered there. We had the same approach seen when this case moved on to the Court of Appeal. The Court of Appeal was also very, very willing to dig into the detail and validity, and essentially undertook the validity analysis again. In overturning the first instance decision in which the PI was granted, the Court of Appeal completely sort of took a very different approach to the validity analysis, and in particular on inventive step. So the Munich local division had applied a very EPO-style approach to inventive step. It identified the closest prior art and applied the problem-solution approach, whereas the Court of Appeal took a more sort of Dutch-style approach and had in fact taken a prior art citation that the Munich division had rejected as not being structurally similar to the claims, and said, actually, that was a realistic starting point for the skilled person. And based on sort of obvious amendments, you would have ended up with the claim. So interesting to see some very different approaches between the local division and the Court of Appeal there. The Court of Appeal also clarified the approach on the standard of proof and burden of proof in PI proceedings. So on the standard of proof, the UPC agreement and the rules of procedure refer to a sufficient degree of certainty being required on validity and infringement. The Court of Appeal confirmed that means balance of probabilities. So it must be more likely than not that the patent is valid and infringed. And the patentee has the burden of proof on infringement, and in inter partes proceedings at least, it's the defendant who has the burden of proof on validity. Another interesting point, there's been a very different approach to the assessment of validity in another sort of provisional measures decision. So in Secor and Novawell, which is a sort of SASI evidence preservation order by the Paris local division, the judges in the Paris division adopted an approach that there was a presumption of validity unless there was a revocation action in play. So no consideration of validity at all in that case. Obviously, it's not a preliminary injunction situation. That's a SASI to get hold of evidence. But the legislation doesn't distinguish between the two. So it will be interesting to see whether there is, in fact, a difference or whether that's just reflecting a difference between different local divisions. There are a few other points where we've got a few contradictions so far in the decisions by the local division. So one is on the approach to jurisdiction. We've seen some divisions being very, very strict on jurisdiction. In Amen Suppenor, the Helsinki local division rejected the PI application on the basis that this was a patent that had been opted out of the UPC and the patentee tried to opt it back in, but there was national litigation that preceded the UPC start date, and the Helsinki division said that means you're blocked under Article 83.4. In contrast, 10x Genomics and Nanostring on the parent case, this is the one where the PI wasn't actually granted, but on jurisdiction, the court effectively waved away the defendant's concerns on this, despite the fact that the same patent had been enforced in Germany, and there was already an injunction in place in Germany against Nanostring on the same patent. So a very lenient approach to jurisdiction there. Similarly, on claim interpretation, we've got one case, SES and Hanshow, where the Munich local division applied a file wrapper estoppel approach to refer back to the original claims when construing the granted claims of the patent. And then in Autobox and Mammut, the Düsseldorf local division said the prosecution file should not be taken into account when interpreting the patent. So points we hope that will be ironed out in future and that the Court of Appeal will clarify. But at the moment, a little bit up in the air. Finally, very quickly, I was just going to cover some of the early access to documents cases in the UPC, as this is a bit of a hot topic at the moment and subject to some debate. By way of background, Rule 262 of the Rules of Procedure was amended in the final draft shortly before the rules were finalised. Previously, all documents in cases were going to be made available to the public, but when the rules were amended, there was the rules distinguished between decisions and orders made by the court, which would still be made available to the parties as of right, and then written pleadings and evidence, which would only be made available on reasoned request to the registry. And at the time, assurances were given by the UPC drafting committee that the threshold would be very low for these reasoned requests, and this had been introduced mostly to deal with GDPR concerns. But as you can see from the table here, that doesn't seem to have been borne out in practice so far. So based on public information, we are aware of 13 requests for documents so far. Many of these are test cases filed by patent attorney and law firms, including Bristow's, to try to work out exactly what will be acceptable as a reasoned request. So again, based on what we can see publicly, our understanding is that 7 of these requests have been rejected so far, 5 haven't been decided yet, and 1 has been granted, although that decision has been stayed pending appeal. So to give some examples of reasons that weren't considered valid, in Astellas and Osaka, the applicant wanted to be informed of the proceedings for the purpose of education and training, rejected. In Sanofi and Amgen, the applicant's client was interested in the patent at issue and the validity of the patent. That was rejected. And in Joseph Franz Nelson and orthoapnea, the applicant wanted to understand the order and the standard of validity and infringement applied. Again, that was rejected. And in these cases, the divisions explained that the reasons weren't sufficiently concrete and legitimate reasons for access to be granted. And all of these points could be achieved by looking at the decisions or orders, by studying the patent, or by looking at the EPO file. So our one outlier so far where the request has been granted is in Ocado and AutoStore. The Nordic-Baltic division agreed with the applicant here that being interested to see how the claim was framed, and for the purpose of the broader public interest in there being public scrutiny and discussion, those were good reasons, and they said yes. However, that decision was appealed. In fact, the appeal hearing took place yesterday. And in the meantime, the order was stayed, so the documents haven't actually been made available yet. And there have been a few interesting updates in the meantime. Bristow's and Matheson Squire both filed separate applications to intervene in the case on the basis that they had outstanding applications for documents in parallel cases, but they were rejected by the Court of Appeal for lacking legal interest in the outcome of the appeal. Then the Court of Appeal, after inviting the parties and the applicant to make submissions on the point, issued an order requiring the applicant, who is a UK solicitor applying as a member of the public, to appoint a UPC representative to make the request for documents. And they said that was on the basis that a request for documents is an adversarial process and there might be legal consequences, although they don't explain what the legal consequences are. So, as I said, the Court of Appeal hearing took place yesterday, and our colleague Greg Bacon was there. Apparently, the Court of Appeal didn't give anything away in terms of what their decision was, but they said they'll hand down the decision as soon as possible. The applicant for the documents here really took the Court of Appeal's advice to heart and didn't just appoint one UPC representative, but appointed 8 UPC representatives from 6 different jurisdictions and a mixture of patent attorneys and lawyers. I think the idea was that we'd get a real representation of different approaches across Europe. But unfortunately, at the hearing yesterday, they were given a very strict time limit. So I think it was half an hour for the applicant to present their arguments. So couldn't get that much in that time. But we'll see what happens there. I'm going to hand back over to Dom now to look ahead to 2024.
It's kind of interesting. I think that, as the UPC is obviously very clearly quite tight with documents, the UK seems to be going the other way. I don't know if you're aware that there's a consultation going on with the civil procedurals at the moment. We already have third-party access to pleadings and orders, judgments, no problem. The proposal is that we will almost as of right make witness statements and expert reports in patent litigation available upon request to third parties. So we're going the other way to the UPC and making things really very available indeed now in the UK. That goes through. Okay, 2 slides from me to finish. It's really just to tempt you to come back next year by telling you what's on the horizon, starting with the UPC. Obviously, the system will grow and become more interesting. We've got those merits decisions in the pipe that Charlie mentioned. Not running strictly in order, of course, we wouldn't expect it to go that way, but Sanofi and Amgen was the first case filed. It won't be, I don't think, the first trial that gets heard. I think that's going to be Abbott and Dexcom in May, so early summer to look forward to some action at first instance there. Charlie's mentioned the Milan Central Division opening its doors. Ireland the Irish question will be answered this year, which will be exciting. Referendum date is now 6th to 9th of June. There was a, you might remember, there was a time when the Irish referendum on the UPC was coupled with a rather provocative other referendum on the sort of the place of the family in Ireland. So some people sort of said, you know, the woman's place is in the home. It wasn't quite like that. The Irish had decided that you know, married couples were the true basis of a family unit, and that mothers should do the caring. And obviously, you know, that's a very old-fashioned view. So the hope was that they would change that view through a referendum, and they held it on International Women's Day last week. And the thing wasn't voted through. The Irish public said, actually, they would like to keep things in this very traditional way. Thank you. So surprising, and in a way, I think, thank goodness the UPC wasn't coupled with that, because if somebody doesn't know what they're voting for on the ballot paper, okay, they'll just follow the same way. I don't know what it is, so I'll just vote the same. So we might have lost the UPC in Ireland if it'd been on that same ticket. As it is, it's going to be coupled with European and local elections. So hopefully we'll get a good turnout. See what happens to the Irish referendum in June. Finally, Court of Appeal is bound to play a greater role. We've only had about 3 or 4 decisions so far, so as they come through, particularly on the more substantive legal points, we'll get some clarity and hopefully some harmonisation on some of those questions that Charlie mentioned that are at the moment are a little bit out of step. In the UK, fans of Frand will be pleased that we've got another heavy diet of telecoms stuff coming up for you next year. Sorry for the life sciences people like me who don't have quite so many interesting cases to look forward to. But at least on the Frand side of things, we've got the Supreme Court hearing in Apple and Optis looking at the availability of Frand injunctions. We've got 2 more Frand determinations, so that'll be double the number that we've got so far. Give us a few more data points on that. And an implementer-driven case, if you pardon the pun, by Tesla against Avanci on whether the SEPs held there, some of which are held by Interdigital, are Frand or not. So quite a lot to chew on the telecom side. On the life sciences side, there is an interesting case that we're aware of on plausibility in the Teva and AZ case on if I can read this, dapagliflozin. So that'll give us another data point on plausibility and whether or not we really are an outlier when it comes to the interpretation of G2 of 21. I think that goes to the slide that Katie had that shows that we're a little bit out of step perhaps with some of the other decisions in Europe at the moment. And on the SPC side of things, staying with life sciences, possibly an interesting decision on the Merck. This is German Merck, has a case pending relating to cladribine. And the point here is that Merck is saying, well, we had a legitimate expectation that we'd get an SPC on our patent because when we applied, the law was governed by NURIM. If you remember, if you're familiar with your SPC law, there's a brief period of time when you could get an SPC on a second medical use patent following NURIM, but then not long after that, Santen changed the law and you can't have one anymore. Well, Merck said, well, we applied when NURIM was good law, so can't we have one on our second medical use patent? Now, the interesting point here is that the UK Court of Appeal, which will hear the case, does have the power post-Brexit to depart from the CJU. And the UK Court of Appeal was very pro the idea of second medical use SPCs when it was the referring court for the NURIM case. And if you go back and look at that decision when it happened, you had some judges in the UK saying if the regulation doesn't allow for second medical use SPCs, it's really not fit for purpose. So just maybe they might sort of pick that up and say, well, we're going to depart from the European position here. Maybe in the UK we'll allow ourselves to have second medical use SPCs. Personally, I doubt it, but we shall see. You'll have to come back next year to find out. That's probably all there is to say for this year, other than thank you for coming along. It's great to see you all, and please do join us for a drink afterwards.